Hi, my name's Mark Pizzacalla and welcome to this edition of 3 Minutes with Mark. Today I'd like to talk about the personal services income rules. Now you might say, well, what's so exciting about that? Well, there's a couple of very interesting federal court decisions that have just been handed down. But firstly, what are the personal services income rules, or otherwise known as PSI rules? Now, these were introduced to make sure that individuals weren't able to set up their business in a company or trust when really the income that was being earned was from their personal efforts and skills and should have been taxed in their hands, as opposed to a company or trust situation whereby you can lower the amount of tax that's being paid. So I have no issue with the rationale behind the actual rules themselves, but they are quite complex. And the first case is called Fortunato's case. And in this particular case, it looked at the unrelated clients test. Now, one of the ways of not being subject to the rules is if you have unrelated clients that you're providing services to, that you are advertising those services, and that there's a causal connection between the advertising that's taking place or the invitations being made to the public and the work that's being derived. Now, in this particular case though, the ATO said, well, we're going to tax the taxpayer because they couldn't quite understand that causal connection. To cut a long story short, the taxpayer said, well, hang on, I actually am advertising, I am putting offers out to the public. I'm using a platform called LinkedIn. And guess what? The federal court agreed with the taxpayer. So the takeaway really is that, yes, there needs to be a causal connection between the advertising and you offering your services to multiple clients, but there might be other steps in between, and those other steps might not be reasonably apparent, but they are there and need to be taken into account. The next case is Douglas case, and in this particular case, it looks at an exception to the rules, which talks about the results test. Now, with the results test, if you can show that the work that you're carrying out is to produce a result, that you're using your own tools of trade, and also that you're rectifying, you're taking the liability when that work is not properly performed, then you fall out of the PSI rules and you can conduct that sort of activity from a company or trust. Now, the interesting thing with Douglas' case is, and it's always a situation when you're talking about personal services, is that he was a consultant to a very large company that we all know, which is a mining company. And in providing those services, interviews were also taken with other taxpayers that were involved in the project. The court found it difficult to actually conclude that what was being done by the company or the trust was in relation to producing a result. It was, the way it was concluded was that really all that was happening was that the person was being paid for the provision of services, and also in that particular industry there seemed to be a lack of evidentiary requirements which demonstrated or showed that the taxpayer was taking liability for the work if it was not appropriately done. So look, they're the two cases in respect of PSI. They are difficult to follow. They shouldn't be that hard, but as you can see, a number of courts have arrived at different decisions in relation to the PSI rules. So please make sure you do your homework before advising clients or deciding to enter into that sort of a structure yourself. Speak to you soon. Have a great week.